Companies law can also be referred to as corporate law, business law, or enterprise law. Is the body of law governing the rights, relations, and conduct of persons, companies, organizations, and businesses. The term refers to a legal practice of law relating to corporations or to the theory of corporations. Talking about company law, we have what we call promoters or promoter. That is a person that takes part in forming a company and raising capital for it. Takes part in forming a company and raising capital for it. It may choose from three business organization forms. These are three business organization forms. These are: 1. Sole proprietorship. 2. We have partnership. And incorporated company. That is 1. 2. Incorporated. The choice, if rational, should be informed by the scope of the proposed business, the available capital, the managerial staff, and the requirements of the law or regulation on that particular business. The choice of business, organizations, their formation, flotation, management, and winding up are determined largely by the Companies and Allied Matters Act. Companies and Allied Matters Act. C20 of the Federation of Nigeria 204 reviewed in 2020 to provide a robust framework for reforming identified onerous legal, regulatory, and administrative bottlenecks, which for 3 decades, 30 years, have been doing business in Nigeria substantially difficult, particularly for micro, small, and medium enterprises, and hindered investments into Nigeria. In 2004, Companies and Allied Matters Act, that is CAMA, was reviewed and signed into law by the President. However, there are some content provisions of the revised CAMA that has been subject of litigation, especially business owners, some business owners, religious bodies. I understand that CAN has taken the federal government to court on some of the provisions encapsulated in the 2020 Kamal Act. So we're making progress. Types of business organizations, we have mentioned some, but we'll discuss them elaborately. Now, sole proprietorship. The sole proprietorship is known as sole trader. Individual entrepreneurship or proprietorship is a type of enterprise owned and run by one person in which there is no legal distinction between the owner and the business entity. A sole proprietor does not necessarily work alone. It is impossible for the sole trader to employ other people. The sole proprietorship, otherwise known as one person business. One person business. Just like we said, you can't differentiate between the business and the owner of the business and the entity. The owner is therefore responsible as he cannot differentiate them for debts and other obligations of the business. Without any limits. A sole proprietorship may not be registered with the Corporate Affairs Commission, may not be registered with the CAC, Corporate Affairs Commission. If the business is carried on the true surname of the proprietor, the surname of the proprietor is the name of the owner of the business is Jide Chinwe. The first name is Jide, the last name is Chinwe, the last name being the surname. If the name of the business is Chinwe Enterprises or Chinwe Nigeria Limited, the proprietor with the name, first name or initials may not register with the CAC, that is Jide Chinwe. If the name of the business is Jide Chinwe or Chinwe Jide Nigeria Enterprises or Jide Chinwe Nigeria Limited as a one-person business, if the surname and the first name or initials are the true name of the proprietor, the business may not be registered with the CAC. However, the business must be registered if it is carried on under an assumed name. If it is not the name, true name of the proprietor, it could be a different name, a name assumed or formulated just to advance the business by the proprietor, which has no direct reality with the true name of the proprietor. The name has to be registered name. Partnership. A partnership is an arrangement between two or more people to oversee business operations and share its profits and liabilities. In a general partnership company, all members share both profits and liabilities. Professionals like doctors and lawyers often form a limited liability partnership. A partnership is an association of at least two persons, at least, for it to be a partnership, at least two persons must form it for the purpose of business. Purpose of business, profit making, and profit sharing. Types of partnership. We have general partnership. A general partnership is the most basic form of partnership. We have limited partnership. Limited partnership are formal business entities authorized by the state. We have limited liability partnership. We have limited partnership. A general partnership is said to be general partner if all the partners are involved in the management. General. If all partners are involved in the management of the partnership business. In this situation, there is no distinction between business and partners. The partners are liable for all the debts and other obligations of the partnership without any limits to their liability. No limits to liability. Why the second? These are the two most popular types of partnership. Why the limited partnership? Conversely, one or more of the business or members may opt for limited liability, desiring to invest in partnership without taking part in its management. The partnership is then a limited partnership, and the liability of the partnership is limited to the quantum of each investment in the partnership. Liability is limited to the quantum of the investment made. If the limited partner takes part in managing the business, he becomes a general partner without any limit to his liability. A limited partnership must be created formally by drawing up a partnership deed. We'll get to that. Partnership deed. That is an agreement in writing and under seal. An agreement in writing under seal. All other partnerships may be created informally. That is limited liability partnership, limited liability, limited partnership. What are the major features of partnership? Features of limited partnership. limited partner is liable only to the extent of his contribution. Two, he can assign his shares with the other partner's consent. Can assign shares with consent of other partners. Consent. He can dissolve the firm by notice. He cannot dissolve the firm by notice. He cannot dissolve the establishment by notice. He cannot bind the firm. Formation of partnership. Formation of partnership may be formed through an agreement with or without formality. Through an agreement with or without formality. It may also be formed by default through the fact of holding out person as if they were partners. By default. Holding up person as if they are partners. Or the were, because it will be in the past. Where there is an agreement, if it's an agreement, it may be oral or written or under seal. The ordinary rules of contract apply. Ordinary rules of contract apply to determine if there is a valid partnership agreement. A written partnership agreement is called Article of Partnership or Partnership Deed if it is under seal. A written partnership. Agreement called the Article or Partnership Deed if it is under seal. The agreement may be varied by subsequent agreement, express or implied, between the parties depending on the nature of the original agreement. A partnership deed is a formal agreement that contains the terms of the partnership. Partnership deed. Formal agreement. Under seal. That contains the terms of the partnership. Resolution of partnership. A part intellectual